I now welcome officers from CASA, who've probably had enough of Parliament for 1 week. I remind the Senators resolve that an officer of the Department of the Commonwealth or a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and doesn't preclude questions asking for explanations of policy or factual questions about when and how policies were adopted. Officers of the Department are also reminded that any claim that would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the basis of that claim. So if you could all give your name, rank and serial number. And could I just note for Hansard purposes, if additional officers come to the table, because of the signs just pointing that way and Hansard's that away, if they could give their name so we've got some identification. So thank you very much, Mr McCormick. If you'd like to make an opening statement, you don't have to, and give your name, rank and serial numbers, we'd be delighted.
Thank you, Chair. John McCormick, the Director of Aviation Safety, Civil Aviation Safety Authority, and I'd like to thank you and the committee for asking us to be here today, and we do not have an opening statement. We're quite happy to take questions after the introductions are done.
So it may be necessary just to run along the table and say who you are before we begin questions.
Thanks, Senator. Roger Weeks, Manager Flying Standards Branch.
Max McGregor, Manager Southern Region CASA Operations.
Jonathan Aleck, Associate Director of Aviation Safety.
Terry Farquharson, Deputy Director of Aviation Safety.
Greg Hood, Executive Manager Operations.
Peter Boyd, Executive Manager, Standards Development and Future Technology Division.
Thank you very much, Senator Zenfron.
We're here. I know you've been back to this quite a number of times, and this has been your attendance today has been triggered as a result of the media reports of a show cause notice issued with respect to Tiger Airways. You may have heard Tiger's evidence today, which they, and I think they were circumscribed to an extent to what they could say, in the sense that they would prefer to comment more after the process has been dealt with. Can I just go to the process that you provided Tiger with a notice, a show cause notice, I think on the 23rd of March, and there was a response on the 13th of April. What can you tell us? What can CASA tell us about the process and the show cause notice itself and the content of that notice in the context of your ongoing investigation?
No, thanks, Senator. I think the issue with show cause notice, in general terms, if I could start there, it really is just another one of the options that we have available in our regulatory framework. In other words, there are numerous escalations of levels. There are things that we do because our primary focus, of course, is the safety of the Australian public. Whether there is an actual vehicle or what vehicle is used depends on the amount of information we have, etc. So to us, this is business as usual. This is what we do. And I think I've said here before, we try not to conduct our business on the front page of the Sydney Morning Herald. So what we do is to regulate aviation safety.
I think it was Daily Telegraph in this case.
Thank you for that correction.
Well, that's got no credibility, that.
As for actual timelines or the show cause notice process, a show cause notice, if one is issued to someone, there is a period of time for which they have to respond to the issues we raised. It's 21 days.
And that was done in the 21 days in this case?
We had a meeting with Tiger on the times that you mentioned. At the end of a 21-day period, there is normally an opportunity for what's called a show cause conference, and where the operator brings back their answers to the issues we've raised. And of course, it is an ongoing process. When these things are in place, it doesn't end there, because we have to assess the responses from the particular airline, whichever one it is that, or operator that has had the show cause notice, and then we work with them and continue to work with them until the issues are satisfied to our satisfaction.
I just want to go to the issue of just culture and something that Mr Davis, the Managing Director of Tiger Airways, said that I asked him a question as to whether any of the matters whether the show cause notice in whole or in part related to information that Tiger had volunteered. And as I understand it, there's a culture where you encourage airlines to provide information about incidents to build up that culture of safety. That's pretty axiomatic, isn't it? That you encourage people to come forward with information.
Well, very much so, Senator. I think how any operator, how we become aware of an operator's status, shall we say, is a mixture of our own surveillance. We see the electronic safety incident reports. We see the information from ATSB. We see information that's come to us by whistleblowers. We see information that's come to us on the mandatory reporting that each operator has. So it's a mixture of all those things that inform our regulatory opinion.
If I could just go to the ICAO guidelines on occurrence reporting, which I'm very familiar with, but where it says, in part, the objective of mandatory occurrence reporting is to prevent safety occurrences such as accidents and incidents, not to attribute blame or liability if they happen. The person filing a safety report needs to have a strong assurance from the regulatory authority and the employer that prosecution or punitive actions such as suspension of licence will not be sought unless the unsafe act is deliberately committed or gross negligence is demonstrated. And that's axiomatic to just culture, isn't it?
Yes, Senator.
Yeah. So just further to that, Mr Davis in his evidence, as I understood his evidence, said that I asked him whether in whole or in part the show cause notice was as a result of material that was volunteered by Tiger to CASA. Are you able to comment on that? If that was the case, if the show cause notice was triggered in part or in whole as a result of material that was volunteered by Tiger, how does that work in with the ICAO guidelines in relation to that? I'm just trying to understand how that works in terms of the just culture environment.
Dr. Aleck, as I think I've said before, is the chair of the ICAO working group or committee. I think it's the status of it in our task force looking at just culture. So perhaps I can ask him to give you some background information on that.
Sure.
Might help
and in the context of this, in the context of what as I understood Mr Davis's evidence, that I don't think he was complaining, he just stated a direct answer to a question, that if they've copped a show cause as a result of volunteering information, does that militate against a just culture environment?
Thank you, Senator. Jonathan Aleck, Associate Director of Aviation Safety. I think, Senator, the answer to that has to be no, that it doesn't compromise the principles. And the reason for that is, and I think in the information that we tabled with our submission that reflect Australia's position on the development of that concept. In no case, and ICAO is, the Secretariat is certainly on side with this, should a just culture environment, which was really generated for ensuring and encouraging reporting within an organization, if that information is provided to the regulatory authority, and if on the basis of that information it becomes necessary or appropriate to take safety-related action, in no case should that process prevent or impede such action from being taken. I must say that the provisions in the ICAO guidance material are under review, and one of the remits of the task force for which I represent Australia and of which I'm chair is to revisit that language in part to examine some of the problems that can arise.
Can we go to the existing language? And Dr. Aleck, I know that the pilots I speak to speak very highly of your expertise and your input with ICAO. The current wording is that that prosecution or punitive actions such as suspension of licence will not be sought unless the unsafe act is deliberately committed or gross negligence is demonstrated. So there's that proviso, so that unless it's deliberate, unless it's gross negligence. Mm-hmm. So presumably that the intent of that is that if they've slipped up on something and they've made a mistake, they report it, then the idea of that is for everyone to learn from that and for there to be an improvement in the safety culture of the organisation, presumably across the board if it's a systemic issue. I'm just trying to see whether, and again, I know you're constrained in terms of what you can say about this investigation, but if an airline, can be any airline, volunteers information, and there is impunity, and it's not gross negligence, let's make that assumption, and it's not a deliberate act, may some airlines think, well, you know, maybe we should just volunteer the absolute minimum stuff that we have to. Would that militate against people being as open as possible as part of the just culture?
It could do, Senator, and I guess the only comment I'd make in response to what you said, which I agree with, and you have correctly expressed what the guidance material suggests. The problem there is that the notion of a suspension, and I'm not predetermining any action that CASA may or may not take, that a suspension is necessarily punitive action. A suspension of its authorization may in fact be a step necessary in the interest of safety. It is sometimes necessary to prevent an individual or an organization from continuing its operations, and I reiterate, I'm not suggesting what the outcome here is necessarily going to be, in the interest of safety, and that's the problem with that notion.
And I think everyone here in this room, safety has to be the absolute priority. But can I just go to the CASA annual report, the 2009-2010 report at page 158, just refers to show cause notices issued in 2007-8, 21 show cause notices, 2008-9, 33, 2009-10, 27 show cause notices. Can you indicate, of those show cause notices in 2009-10, did any suspensions arise out of that?
Yes, I can actually give you those figures now. Sure. For 2009 and 10. In fact, I can give them some granularity in relation to holders of air operator certificates authorized to conduct regular public transport and charter operations. In 2009-10, of the 27 show cause notices issued, 9 of those were issued to holders of AOCs that are authorized to conduct those kinds of operations. As a result of those show cause notices, 1 resulted in a variation. There were no suspensions.
Sorry, can you explain what a variation is?
A variation means if conditions are imposed on the operator, they can continue to operate but subject to some new conditions. There were no suspensions, because a suspension is effectively a temporal cancellation, and it doesn't achieve anything other than take someone out of the air. There were 5 cancellations of AOCs in that period. That's about 2/3 resulting in enforcement action of one kind or another. If you're interested, Senator, in the period of 2010 to yesterday, there were 21 show cause notices issued.
Just ask that, yeah.
Did you want these figures?
Yes, please.
Yes, please.
Yes,
21 show cause notices issued to holders of AOCs authorizing RPT and charter operations. There were no decisions to vary. 2 certificates had been suspended and 2 had been canceled. So just over half resulted in enforcement action. So the important point there is that far more show cause notices are issued than enforcement action is ultimately taken, just because of that process.
And before I get into some more specific details, we heard from the Tiger Airways representatives about the difference in the CAA because of their familiarity with the Civil Aviation Administration in the authority in the UK, where it seems to me that there, as I understood it, there is a higher standard before a determination is made, but then the determination is made. And as I understand the show cause process here in Australia, there is a lower standard, but it's coupled with procedural fairness and natural justice. Is that, how would you characterise the two?
Well, I'm perhaps a bit biased. I do think that the Australian system is fair. I don't think that the UK system is unfair, but the difference is that in the UK system, all of these determinations are made within the Civil Aviation Authority. And once the determination is made and notice is served of that determination, if that matter can't be resolved between the operator, the holder, and the authority, the only recourse is to the courts. Our process builds in a much more rigorous procedural fairness regime, in the sense that we are required by law to serve a show cause notice that specifies what our concerns are and what the reasons for those concerns are. I don't know that the bar is necessarily higher or lower in either case. I think that probably varies from instance to instance.
It wasn't a criticism to say the bar was lower. It's to say that maybe if it's a different system, you might bring things to your attention and issue a notice more readily than a determination can be made under the CA.